Welcome to the first ever Talk Shop with Tribal Land Staff. This series of pilots beginning today provide networking opportunities to land staff across Indian country as a way to provide further professional development on specific issues that many of you have had questions or comments about based on past webinars that we've had, but also through the evaluations that we've asked many of you to fill out following these webinars, in addition to some of the conference feedback that you give us every year. And so today, it's going to be a little different. It's not like the typical webinar that we have. This is an hour session that provides you with opportunities to communicate with others in the field who have had experiences, in this case, with rights-of-way. A big topic, popular, very important. This is definitely a place for you to be able to have that conversation. So how do you participate? As usual, you can go into your chat box and click in comments and questions. We have NTLA board members who will be leading this conversation today, looking at the chat box, but also you have that raise your hand feature. If you look at your reactions button, you should have an option to raise hand. So by doing that, it'll let us know that you would like to ask a question through audio or video. So as we move forward over the course of this next hour, I encourage you to think thoughtfully about the kinds of questions you want to ask or the comments you want to make. And say someone asks a question and you have some important things you want to add to the conversation, that's absolutely okay. We just ask that you do, in fact, raise your hand. That way we can unmute you. Otherwise, it could be chaotic, right? We're a wild bunch, tribal land staffers, after all. So this is recorded. We'll see what we can do with this afterwards, post it on Vimeo like we do our other pieces. One other part I want to mention, and I'm going to say this at the very end as well, is that we have a full webinar next Wednesday at noon Central on FEDA Trust, post-submission NEPA survey. So I'm going to post that registration link in the chat right now, but also at the end of our session. So that way you have that information, you can begin registering. If you know people who would like to attend that session, send that link to them, because that's the direct link to the form, okay? And for some of our participants, they have some issues with the firewalls to be able to get through that. So please do use the information I'm about to send via chat. Now, without further ado then, I am going to pass it on to NTLA Board Chair Andrew Orosco to introduce himself and the other board members, and we'll get started.
Thank you, Nick. Appreciate the intro, and great to see all of you. I see some familiar faces out there. So thanks for joining us today on the first session of the Talk Shop series. As Nick stated, I'm the chair of the National Tribal Land Association. I also serve as the planning director for the San Pasqual Band of Mission Indians in Southern California. I am a state licensed land surveyor and also a CFEDS. So, my experiences in terms of rights of way are really specific to the survey aspect of it. So I hope to be able to contribute, but I'm also excited to be here to have this dialogue, this networking opportunity. Rights of way impact us all, and this topic, I think, is a great way to start the series off. We all have faced a wide range of challenges, successes, and issues. So I think each one of the participants here, along with my fellow board members who are participating, are excited to hear that. And so I encourage all of you to participate, ask those questions, and that way we can make this a a meaningful and successful session and learning from one another because there's such, like I said, a wide range of issues within rights of way. So thanks again for being here. And with that, I will pass it on to my fellow board member, Brenda Tomaras.
Good morning. Brenda Tomaras. I am an attorney out here in California and work with tribes on a lot of land use issues. And that's really all I have to say. So is Sarah on? I can't tell.
Yep, I'm on.
Okay, go for
it. Thanks, Brenda. Hi, everyone. My name is Sarah Rubidoux Lawson. I am also an attorney up in the Seattle area. I am also on the NTLA board and have been for probably 5 or 6 years now. I think I stopped counting after 2. But I've also done a lot of work with rights of ways, both when I was in-house as a real estate manager for a tribe up here in Washington, and then of course as outside counsel for tribes in my private practice. I'm also an enrolled citizen of the Iowa tribe of Kansas and Nebraska. And I do want to say that anything I say on the call today is not legal advice. I am not your lawyer. With me being on the call today, I am, not establishing a lawyer-client relationship, and I just have to give that disclaimer because being a lawyer. So that's it. Brenda, do you have a similar disclaimer that you would like to give?
I agree with you. Yes, there. Although I wasn't anticipating really being that brilliant on this, so.
I think I see Katie Free from the NTLA board. Katie, do you want to introduce yourself?
Yes, thank you, Sarah. My name is Katie Free, and I work for the Osage Nation under a compacted service for the real estate services out of Eastern Oklahoma region. I'm a realty specialist, and I'm here to learn as well. Right now, I do leasing and deed of trust, and I am curious to see what everybody has to say. Thank you.
And it looks like we have one of our new board members, Mr. Russell Bellamy. You want to introduce yourself?
Sure, yeah, sorry I'm late. My name is Russ Bellamy. I work alongside Katie, the Osage Nation Real Estate Services Department. I am the GIS coordinator and the field inspector for real estate services. And I am here to learn as well.
Great, thank you for that. And Matt, I gotta throw you in there. The former chair of NTLA is in the house. Good to see you. It's been a while. How you been?
I'm good, man. Doing very well, staying busy. I'm sure like everybody else in here is. It's pretty cool to see this. I think this is something that I always wanted to do. And I hope everybody gets something out of this today, because this is probably the best way for all of us to ever, network and kind of brainstorm on ideas and ways to get around the BIA and all of that fun stuff. So glad to be here and hope it goes well.
Awesome. Thanks, Matt. Good to see you again. So I wanted to start off with maybe just a question. And, since Sarah and Brenda, obviously represent clients with on different topics, different issues, I'm going to go ahead and ask Sarah, since the new regs, the change in the regs in 2016, have you seen a big change in a good way with those modifications to the regs? And this is a two-part question. And what are some successful methods or approaches you've seen tribes or individual landowners take to streamline the process?
That's an interesting question. Thanks, Matt, or not Matt, Andrew. So I think that the two changes that stick out to me as being most successful so far under the rights of way regs are the clarification that was made as to, I think, landowner rights and piggybacking of other rights of ways in an existing right of way. So there were all these changes that I had seen rights of way holders that had like mortgaged their rights of way without consent of the Bureau of Indian Affairs, or had piggybacked rights of way under prior case law that said that that could happen. And the new regulations, when they came out in 2016, made some clarifications or some changes to that, where mortgages expressly have to be approved by the BIA. That piggybacking is allowed only if it is allowed under the current right-of-way grant, but that it is not allowed if it is not a purpose that is currently under that right-of-way grant. And then there was also a provision in there, landowners had always impliedly, I think, had rights to take up issues like trespass on their own, but there was never anything expressly written to that extent in the regulations. And there's a specific regulation in the regs. I don't know the citation for it off the top of my head, but there's a specific regulation that says that landowners can take up trespass issues on their own, or other other right-of-way compliance issues on their own, so that they don't have to wait for the Bureau of Indian Affairs to act. And that's been really helpful. One case that I can think of off the top of my head is a case out of Oklahoma, Davila versus Enable Midstream Partners, where the landowners, the Indian allotment owners on an allotment in Oklahoma, had a oil and gas line right-of-way that was running through their allotment, and the right-of-way had expired, and they had not come to a new agreement with the pipeline owner. And so they said, we want you to just remove your line. And the courts actually went through the federal court, and the federal court agreed that, the pipeline owner was in trespass and that they would have to remove their line. And so I credit the new rights of way regulations for really sort of strengthening the ability of individual Indian landowners to take up right-of-way compliance issues on their lands. The other success, and I've only seen this sort of play out recently, but the other success is there's a provision in the regulations. It's 169.4, which I just had it pulled up on my computer, which is why I sort of have it in front of me here, that allows a tribe to grant a right-of-way to a wholly owned tribal entity without having to obtain the approval of the Bureau of Indian Affairs. And that should really speed up some rights of ways to, like, a tribal utility authority who needs to put in electric lines or water lines or something like that. They don't have to necessarily use the BIA process in order to do that, and don't have to obtain BIA approval at the end. As long as it's a tribally owned entity and it's an entity owned by that tribe, they can just go ahead and get the permission of the tribal council in order to do that. And I've seen recently that Navajo Nation, which tends to be sort of out in the lead on a lot of these Indian lands issues, Navajo Nation about a year ago adopted what they call tribal access authorization regulations. So they're actually internal tribal regulations that establish a process for any of the tribally owned utilities to obtain a right-of-way without having to later get the approval of the Bureau of Indian Affairs for that right-of-way. And it really helps speed up the process, simply because there are not all of these hurdles that the utility has to jump through, including having to, meet NEPA compliance, because, when you have BIA approval at the end of the line, that's a federal action that requires compliance with NEPA. So I think I saw a question in the chat, and the section is, it's 25 CFR 169.4. And then you have to scroll down to B3 Roman numerat 4. So 169.4 B3 4. which says you don't need a right-of-way if you are an independent legal entity wholly owned and operated by the tribe that owns 100% of the interest of the trust or restricted interests on the land. It just says that the tribal governing body must pass a resolution authorizing access without BIA approval. I should note there too that that only authorizes access across tribally owned lands and does not include individually owned lands. And so if there's any portion of the right-of-way that would go on an individual Indian trust allotment or a fractionated allotment, that portion of the right-of-way would have to go through the BIA process. So that was a really long-winded answer, Andrew.
No, and that's like I said, for me, I think that's there's little nuggets that I'm going to be, jotting down and doing some of my own research, because, our reservation is entirely trust. We don't have any allotments or any other types of land, and so it's interesting to hear about different situations like that. So I think I do have another question, but I think I see Matt's hand raised.
Yes, sir. Sarah and I just wanted to clarify about this because I just went through this. Does that apply to a federally recognized charter like that comes from the tribe? Do you know the answer to that? Because like I just went through this, and if I don't know if it does or doesn't, but I think it's an interesting question that I doubt the CFR probably acknowledges.
Well, so the CFR is, fortunately and unfortunately, pretty vague and pretty broad. Yeah. So all the CFR says is that it's an independent legal entity that is wholly owned and operated by the tribe. So if you're talking about a federally chartered corporation like a Section 17 corporation, a Section 17 corporation is an independent legal entity from the tribal government. And it is wholly owned by the tribe. I mean, it has to be. It can't be a Section 17 otherwise. Yeah. So yeah, if you're dealing, I would say if you're dealing with a Section 17 corporation, then it meets the criteria of, B3, Roman numeral 3. Sorry, did I say B34? I meant B33. It meets the criteria of B33 to have a right-of-way granted to it by the tribe across tribal trust lands without BIA approval.
Nice.
Yeah, and so that kind of leads to another comment question, I guess. And so, I'll direct this to you, Sarah, but please, anyone who has experience or an answer, this is a conversation, so please raise your hand or speak up. In looking at the new regs, they stress that, if there's a decision that needs to be made or something along those lines, it's really encouraging or favoring tribal self-determination. So Sarah, have you seen that play out? Like, the question that Matt asked, that you said the regs are sometimes vague, which allows, tribes to use that to their advantage. Have you seen instances of that?
I don't know that I've seen anything that would allow a tribe to abuse the regs to their advantage. If we're talking about, places where the regulations are vague, but also specific at the same time. So, and I'll use this section that we've been talking about just as an example. That section says that the tribal entity just has to be an independent legal entity that is wholly owned by the tribe. So that section is not specific. It doesn't say only Section 17 corporations, and it doesn't say only tribally chartered corporations, chartered under tribal law, or entities formed as an LLC under tribal law. It's sort of not specific as to the formation of the entity, so long as it is a separate legal entity from the tribal government and it's wholly owned by the tribe. I mean, theoretically, that legal entity could also be established under state law. It could be a state law corporation. So the reg is not, is not specific. It just says it has to be owned by the tribe and a separate entity from the tribe. So
Gotcha.
that like I said, and this is kind of, it hits to Matt's question. That's good and bad, because Matt had a very specific question about a section 17. And I'm like, well, yes, so long as it's A and B, A is.
Seems like it.
Yeah,
seems like it meets that criteria.
Yes, yes.
Yeah. Okay, so I wanted to bring up another topic that you mentioned earlier, and that's piggybacking. And I know it's something that we're going through right now. San Diego Gas and Electric is putting forth a huge effort to underground all of their overhead facilities. And throughout the years, there have been agreements made, some with BIA involvement, some without, with telecommunications companies such as AT&T. And so we're going through that now. We're trying to go through the records and understand what was legally done, what was not. And so if anyone can speak to that and their experiences and some of the options they did to remedy that, because we're, like I said, we're going through that now, and it's a mess.
Andrew, do you guys not have all of the documents attending that right of way, or?
In some situations we do. BIA has been able to provide some, but there are a few where it appears that SDG&E granted the right of way to AT&T for a fee, and so that's where we're trying to dig a little deeper there.
Ah, okay, yeah. So BIA wouldn't necessarily have those records.
Yep.
Yep.
And as you stated before, in the easement documents themselves, it must expressly state that the grantee has the ability to do that, correct?
Yeah, so in the regulations, if you do a word search in the regs for the word piggybacking, that doesn't come up.
Right.
You will never find it that way. The way you have to find it is it's in the regulations discussions of use of the right of way. And I am looking at 169.127 and 169.128.
And I'm going to attach the link to the CFRs here. That way everyone, I'm sure everyone has this, but just in case.
And so the way the regs are structured, they're always done as sort of a question and answer. And so the question posed in the regulation is a new right-of-way grant required for a new use within an overlapping, within or overlapping an existing right-of-way? So obviously it doesn't say anything about piggybacking in there, but that's basically what it's talking about, is piggybacking. Then it says, the grantee can use all or a portion of an existing right-of-way for a use not specified in the original grant, only if it is within the same scope of the use specified in the original grant. So if it was originally granted for a road, and then they want to, put telecommunications equipment in the road, that does not seem to me like it would be within the same scope.
Right. Yep.
So Sarah, this is Brenda. Let me ask you this, because we've dealt with this. I mean, so what Andrew's talking about, I think, is previously granted easements and things that are already in existence.
Right.
Right. Which I think the new regs should help, but don't necessarily govern. Or is that not what your opinion is?
No, the new regs govern. Sorry, I'm going to turn my camera on so you guys can see like how animated I get about this. Because I'm sure that's part of the fun, isn't it?
Yes.
So, and I have to apologize. I have another monitor set up over here, which is where I have my regs set up. So there is an Easter egg in the regulations that talks about what grants these new regs apply to. So, these regs came into effect in 2016, but 25 CFR 169.7 says, does this part apply to rights of way grants submitted for approval before December 21st, 2015? And basically it says, yes, these regs apply to any right of way that was granted prior to 2016. So it says, if your right of way was issued on or after, then yes, this part applies. If we granted before 2016, this is where it gets kind of tricky. The procedural provisions of this part apply, except that if the procedural provisions of this part conflict with explicit provisions of the right-of-way grant, then the provisions of the right-of-way grant or authorizing statute apply instead. So basically, I always think of this, because there's a similar provision like this in the leasing regulations that were adopted in 2013. I always think of it as the regulatory hokey pokey. So these regs apply unless, when you go to look at the document, there's something in the document that would expressly conflict with what the reg says. In my experience, the document is always silent. So if we were talking about mortgages, for example, there was no provision on mortgages in the regulations prior to 2016, but a lot of right-of-way grantees had presumed that they could just go ahead and mortgage it. So you ended up with this situation where, as we know, working in Indian country, literally everything, every mortgage has to be approved if it's on Indian trust land, whether it's to the original lottee or a leasehold mortgage or whatever. It always has to be approved by BIA. So the presumption would be, from our Indian lands perspective, is that yes, a right-of-way mortgage would have to be approved. But from the grantee's perspective, they were looking at the right-of-way grant and saying, well, it doesn't say that we have to get permission to mortgage it, so we're going to mortgage it. The new regulations contained a provision that say mortgages require BIA approval. And then when you look at this 169.7, even though that is a new regulation that was adopted in 2016, that 169.7 says these regs apply to anything granted before 2016. So even if it was granted in 1985, and you look at the document and the document doesn't say anything about whether or not you have to get BIA approval or whether this new use is permitted, then you go back to the reg and you say, okay, well, the reg says this. That was probably a really confusing way of saying, what you do is you look at the reg first, look at the words of the document to see if the document says something different or that conflicts with the reg. And if it doesn't say anything, it's usually silent, doesn't address the issue at all, then the reg applies under 169.7.
Gotcha.
Yeah.
That makes sense.
Yeah. And I think that there's another provision there. No. So yeah, it's just 169.7.
Okay. It looks like we have a comment from Brianna Joy. It says, I was hoping this meeting would be addressing the changes from the Tribal Transportation and Rights of Way Reform Act and bridging the Tribal Digital Divide Act of 2020. And so, Sarah or anyone, I don't know if you can comment on that.
I have not actually done a lot of work in that area, so I don't have anything to add. Brenda, do you?
No, I haven't looked at that at all.
Okay. And anyone on the call for that matter, we're kind of all in this together. So, if there are comments, questions that, we feel as a group should be addressed or maybe answered on a future near webinar, we can certainly, we'll certainly be tracking these. And so, Brianna, we appreciate the comment and we'll certainly look into that. And Brianna, if you have anything, specific you want to address or a question, please feel free to raise your hand. And it looks like we've got 2 hands raised. Okay, it looks like we've got Katie.
Yes. Okay. So right now what we're dealing with in Osage County is we have a lot of roads that there are no existing easements on for the county. They're cutting through restricted property. Some are cutting through trust property. And we've contacted the county commissioner. We've searched the courthouse and there's no existing easement. So we actually have forwarded this up to the U.S. solicitor, because if they rule that there has to be an easement, there's no adverse possession in Osage County, by the way. So they can't really say, oh, well, it's ours now. And how this happened was, or how this came about, we have a landowner that's wanting to fence in his property completely outside of another ranch to have somebody else use it. And the road cuts off half, like a little bit of his property on the southeastern corner. So what do you guys think about that? Any suggestions, words of advice, thoughts and prayers?
Thoughts and prayers.
We can give you those, Katie.
Thank you, guys. Thank you.
Right here. So yeah, okay. 25 CFR 169.413 is the trespass regulation. But what if an individual or entity takes possession or uses Indian land or BIA land without a right-of-way or other proper authorization? And it says, if they take possession of Indian trust land without a right-of-way, then that is a trespass. And as we all know, there's no adverse possession and there is no such thing as a prescriptive easement on Indian trust land or restricted land. The regulation goes on to say an unauthorized use within an existing right-of-way is also a trespass, kind of hearkening back to Andrew's question earlier. Mm-hmm. The reg says that BIA can take action to recover possession, but importantly, it also says that the Indian landowners may pursue any available remedies under applicable law, including applicable tribal law. And if I were the Indian landowner there, I would probably file an action for ejectment, either in tribal court. I would start in tribal court and see what happens. Again, none of this is legal advice, but I feel like I should give that disclaimer every time I answer a question.
Yes.
Just hang a little sign in front of you, Sarah.
Right.
Just wear like a little necklace.
I'm just going to change my name where it says Sarah Lawson, parentheses, not legal advice, not your lawyer. So I'd actually, when I was working at Muckleshoot, I had a discussion with attorneys in the solicitor's office about a number of trespass cases that I knew that we had. And the solicitor basically told me, look, we got a lot of stuff to do and it's going to take a while. It will take some work for us to get this kicked up to DOJ for prosecution. So to the extent that you can solve this problem on your own, we suggest you do so. And that's where these express provisions about the rights of the Indian landowners are great, because you have a right as expressed in the regulation to take on trespass issues on your own. Now, I had a similar situation to yours, Katie, where I got a notice one day from the city that said, hey, we're going to do an improvement project on this road that is on trust land. And so I went and I dug out my TSR for the property and did not see a right-of-way grant across the property for the road that they were talking about. So I just sent them a letter back and I said, no, you won't be doing any work. I mean, the work was good work, but like, no, you won't be doing any work until you can show me that you have a valid right-of-way against the property. So it did it put the onus back on the city or the county to find me the papers, show me the money, right? And produce the documents that said that they have a right-of-way there. And in this particular case, they did actually have a right-of-way, and all the documentation that I looked through it did appear to be a validly granted right of way according to the statute that was the applicable statute at the time. And so in that case, I just sent it on to LTRO and said, hey, you guys forgot this on your TSR. Can you please add it? And they did so. But that's my story, is I push back on the entity that claims to own it and say, you don't own it, show me otherwise.
So in theory, just all of us just sitting talking, not with our legal hats or anything on, what if my landowner just fenced in his property and put the road with it?
The Indian landowners may pursue any applicable remedies available under applicable law.
You are just telling me what I want to hear. No.
And I would presume that that includes rights of self-help. So if he wants to fence off his property, I would presume that that would meet that regulation.
We are the Wild West out here, so I mean, I'll let you know how it goes.
Hey, Katie, have those roads been in place for a long time?
Well, they've been there since before this current county commissioner took office, and he's been there since 1980. And so the roads existed before then. And so if this actually, if this sets precedence, there will be a ton of roads in Osage County that will be needing easements. And I'm not sure if it's the same with right-of-ways as it is with leasing, but we can do historical appraisals on them, go back, and I don't think there's like a statute of limitations. We just have to prove around when the road was constructed, which I have no idea when it was. There is nothing on file at the county courthouse. So,
Hey, Andrew, some of these roads, when we look back at the surveys that were done prior to allotment in 1906, we can see that the roads were in use, over 100 years ago.
Yeah. And I think that's a common occurrence with, we have some roads like that, before pre-reservation, there were roads cutting through. And so I know that's another topic in and of itself, and what rights they technically have if it's before the reservation existed. But I was kind of curious because you tend to find that on older roads that have been around for a long time.
Yeah, and to that point, Andrew, with these older roads, sometimes there is documentation, sometimes there's not documentation. I mean, I did have an older roads issue on one reservation that I worked on where there was a road that existed prior to the establishment of the reservation. But the question then was, even if this road existed prior to the establishment of the reservation, what's the proper width of the road now? Because the county claimed that it was their standard is a 60-foot right-of-way. But I looked at it and I'm like, but if this road existed in 1877, we didn't need 60-foot rights of ways. We needed like 8-foot rights of ways for wagons.
Yeah.
Right. So what's the proper width, even if it was established prior to establishment of the reservation?
That's right. And then you have the question, was it always in federal interest, right? Did the U.S. own it before it went into reservation status, or was it sold and then brought back? So that's an interesting topic. So thank you for that. I think that's some valuable information there. We're right at about 10:45 almost. So let's get to another couple of hands. I see Matt, put your hand down. You're good? Okay. Linnea?
Good morning, everybody. Okay, I'm gonna try not to dump everything, but I'm gonna just go for it. So
go for it.
Okay, so I'm the general manager of Hooper Valley Public Utilities. I was the former realty specialist, but rights of way, tracks, all of that pertain to my job as well. Water line easements, utilities easements. So one thing that Hoopa has problems with is that we don't even have a read-only access to TAMs. So we have to go one by one to the Bureau, and there's one person working at the Pacific region, no shade, but it's like just to get regular uncertified documents is like pulling teeth because there's just not enough staff there. So our tracks are not updated. Anytime we need a certified TSR, it takes 6 months to a year to get that. So Hoopa Public Utilities is implementing a California Public Utilities grant for broadband infrastructure. And it kind of brings up the question to say, we're building middle mile fiber optic infrastructure. Hopefully we'll get some NTIA funds that we submitted for. But along with that, the telco is attaching to existing poles, whether that be electricity, telephone, what have you. And I know that we talked about the grant and use not piggybacking, but if we have to get, 300 grants of right-of-way, it almost makes the project unachievable within the specific time frame. So if on segment 1, they're attaching to like over 150 telephone poles, and if you pull up the title status report for that, you don't see that original easement. You don't see those rights of way in that tract, although it's all tribal trust properties. So my question, and not that it's legal advice, but if we are a partner in the CPUC grant and we're named in that grant and resolution, can the tribe go ahead and approve the right of way attaching to existing infrastructure, for tribal trust properties and tribal fee? I guess is my thing.
You're on mute, Sarah.
Yes, Zoom just told me that. So on leaving aside tribal fee, because that is going to go subject to whatever applicable state laws and regulations are out there. But on the tribal trust tracks, I mean, if you're talking about poles that you don't have any evidence of a validly existing right-of-way, that that like somebody else claims to own the poles, but you don't know if they are there attaching to any right-of-way, I would contact the owner of the pole, ask to, obviously, if they own the pole, you're going to need permission to co-locate on it, and work that part of it out. And then in terms of obtaining the tribal right-of-way, I would work through the federal regulations, through that regulation that we talked about at the very beginning of the talk shop, and grant myself or my tribal entity a right-of-way through those tracks. I think that's the way. Go ahead.
Yeah, the telco has already had that agreement in place for the overhead use facility agreement. And then again, they're paying that specific company for each individual pole attachment. When I feel like, man, the tribe wasn't even given right-of-way allocations, you know what I mean, for them to be on our land. So yeah. I have a double-edged sword there, is because obviously I want fiber optics to the reservation. We're a rural nature. We need it for, telework, telehealth medicine, distance learning. We need it for all of those reasons. So it's almost like, do we skate, I guess, holding them accountable for them not being there? Because I feel like it's a huge legal issue that probably is in effect on every reservation in this country, in some effect.
Yeah, and that's one thing I was going to say earlier, and I actually forgot when I was talking. To Russ and Katie's point, I have a running theory that rights of ways and rights of way trespasses in Indian country are like the great Pandora's box. That a lot of these roads and these lines had just been put in whatever, wherever over time. And that if you actually went through and did like an on the site, as built analysis or survey of what utilities are there, what roads are there, et cetera, you would find trespass all over the reservation. And this is sort of just based on my experience on one reservation here in Washington that wasn't even that big. It was like 2,000 acres. And there were a ton of water lines, even IHS water lines that had no documentation underlying them. But water lines, power lines, it is the great Pandora's box if you were to go through and actually try to inventory everything that you see on your reservation lands. But yeah, that would be a question. Do you want to kick up a hornet's nest when you are actually sort of benefiting from the hornets?
I kind of do, but you know, that's just me. But that's kind of the larger picture of it. And then I guess it goes back to Andrew, you asking you as a CFET surveyor and a certified surveyor as well. So within the allotments that these fiber optic lines are touching that already have an existing pole use, you do have to, correct me if I'm wrong, obtain consent for appraisal and survey, and then obtain an additional consent from the landowners for the additional right-of-way on the allotted pieces?
Yeah, so I would say yes, generally speaking, but to Sarah's point, I think you should probably take a look at the document itself and see what is listed there as the use, right? If it's kind of a general statement, utilities, you know, things of that nature, you may be able to not sidestep, but you know, be able to grant without going through the entire process. Correct me if I'm wrong on that, Sarah.
So let me jump in, because Sarah may be getting to this, and I want to have her speak to this as well, because she's going to be our expert. So service line agreements are new in the new, and so, you know, this all puts me, what Linnea is talking about kind of all puts me in mind of, you know, the service line agreements between the main utility and individual homes.
Yeah, so service line agreements, what's new in service line agreements is that in the new regs, we got a whole subpart on service line agreements, where in prior regulations, there was like one reg and it was kind of vague. So we got 6 new regulations regarding service line agreements. If these were in fact, and I've seen this happen before, where one residential user asked for a pole drop and the utility company extended it. And then the next residential user asked for a pole drop and the utility company just extended it off the last pole drop. Where they've sort of used these successive service line agreements to expand electrical service to different buildings on an allotment, for example. When they do it that way, the line ceases to be a service line and actually becomes a right-of-way. Because when you look at the reg for service line agreements, it says that a service line is a branch off of a main facility. So it's running off of a main line that's used only for supplying telephone, water, electricity, gas, blah, 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 to a house, business, or other structure. But it's like, it's to one. So when you can't chain service line agreements like that without basically having them function as a right-of-way. But yeah, there's a whole subpart B, 169 subpart B are all the regulations on service line agreements. And I want to make sure we get to Danny before we run out of time.
Yeah,
here.
yeah.
Okay, one last comment. I'm sorry. So we tried to do that with our original fiber optic build, and the Bureau said the same thing, is that you can't extend any more off the original line, and I have no right of way in place to even attach that to. Mm-hmm. So we have these existing poles, and with Frontier, for instance, it's gone through 4 different allocations of ownership. So Frontier didn't even know they had infrastructure. So it's a large Pandora's box.
Yeah.
But anyway, thank you for your feedback.
Yep.
And thanks for asking that, Linnea. It all sounds all too familiar. Not that we have a broadband grant right now, but I'm just trying to untangle this mess. So my question is about, old roads. You guys kind of triggered my memory about like how to handle old existing roads that, we can't even find records of it, like when it was created. The only thing we have is that there is, like on the deeds of fee properties, there is a line that says it's not like location based. There's nothing more in the details than there is a road there. There is a public road there. Doesn't say whose, doesn't say like where it is. It's just there's a public road there. And so, you know, we had a major flood in early 2020, just a month before COVID. It was a fun time. And we were trying to figure out, I mean, it took us months to even figure out how to get that road, like, you know, just re-graveled for the property owners that live adjacent to it that had been impacted by the floods. Some of them, their homes were destroyed, and some of them were, you know, like a little bit higher up, and they still needed the access. And we just couldn't even figure out like who the road belongs to. So like, where do you even start with something like that? Because I've done tons of research. I've looked through, you know, I've looked at the TSRs, I've looked through, there's a couple of tribal properties, a couple of fee properties, since I'm on CTUIR, we're an allotted reservation. And, you know, looked in the, like, talked to the county surveyor, like all of that, and just can't find any records. So like, how do you start? Well, okay, this is a road, it exists. Like, how do we make it functional?
Yeah. And so you've checked the county records, and there's nothing in the county records either. So one thing that I've done in the past is I've just gone to a title company, and I've had a title company do a search and see what they can turn up. Because sometimes the county record doesn't go back far enough, for example, or something like that, where the title company seems to be able to stretch that basically all the way back to the first grant. But yeah, I mean, it's a pickle, because I know that there's all these roads and all these utility lines that are out in Indian country that have no underlying documentation. So yeah, I mean, I think you have to work to find the documentation, and if it doesn't exist, and in this case you have a road, but you don't have any purported owner of the road, one idea might be to look at doing a condemnation. And, you know, tribes have authority to condemn Indian land. So one option could be for the tribe to try to condemn the roadway, just so that they can establish ownership and be able to improve and maintain it. Or perhaps even just asking the landowners for a right-of-way there. I mean, it would be essentially a piggybacking right-of-way, but at least it would have some sort of documentation and allow somebody to be able to, maintain the road. Another thing that we did at another reservation was there were internal roads within the reservation that the tribe wanted to take over ownership of. And the county, in some cases, did claim to own the road and knew that they owned the road. In other cases, they're like, well, we don't really have any paperwork for it, but we've been like maintaining the road for 100 years. And they just turned those roads over to the tribe, sort of almost like as a quick claim. Like, well, we don't know if we have any interest in this road, but if we do, we're going to give it over to the tribe so that it's an internal road within the reservation and the tribe can maintain it.
Yeah, the county, I mean, you know, out here, we're like, the county is kind of like that. They're just like, I don't know, it's not ours. That's all I know. Like, so they're not going to fix it. We can't spend TTP funds to fix it if it's not on our NTTFI, right? Mm-hmm. So it's complicated.
Yep. So there was a comment in the chat from Brianna that said the 2016 regs put the responsibility on the right-of-way holder to document existing right-of-way, and many of these are BIA records, and that's correct. So the owner of the right-of-way should have the information. If they claim to own it, they should have the information for it. It might be in the county record, it might be in the right-of-way owner's records. And there's a provision in there, because one of the things that was happening, or that I at least found was happening on the reservation that I was working on, was that a lot of these rights of ways had been assigned over time. Like someone mentioned that, you know, a utility company had it and it got, you know, assigned or transferred over 4 times. And so you don't really know who owns it now. There's a provision in the regs, and I apologize, I don't know what it is off the top of my head. I should know what it is, but I don't. I think it's under assignments. So look at about 169.207. And to deal with all of these rights of ways that had been assigned by the grantees over and over, and yet BIA had no record, like, you know, the right of way grant was still in the original grantee from like 100 years ago. There's a provision in there that says that if the right of way has been assigned, then the grantee needs to report those assignments to the Bureau of Indian Affairs, just so that the tribes can continue to, or the landowners can continue to monitor compliance with the right of way grant.
Sarah, is that something that has always been in the regs that you're aware of?
No, it was not in the prior regulations.
Gotcha. So in a case where an assignment was executed pre-16, they're technically not required to do that, and it's really, I guess, the tribe's responsibility to track that down, if you will.
No, it's the grantee's responsibility to report that. And I'm trying to find the regulation right now, but there's a reg that says that within 180 days of these regs coming into effectiveness, so this was, you know, 180 days after, I think, like April 1st, 2016, these grantees were supposed to report those assignments to the Bureau of Indian Affairs. I think it's 180 days. I just did a search for 180 and I didn't see it, but it's in there.
Gotcha. That's good to know.
Again, it's the Easter eggs that are in the regulation.
Right.
And there's provisions in the regs too that say, you know, if the grant doesn't expressly allow for assignments, they have to get BIA approval. That's 169.207. And that could be a compliance issue moving forward.
Right. I did want to read one more comment from Brianna. That was right before. It says, this is in regards to the Tribal Transportation Rights of Way Reform Act and Bridging the Digital Divide. So it was something staff in my office was notified 1 hour before a Zoom meeting, August 16th, and comments were due August 18th. I am not speaking on behalf of the tribe I work for, just my personal impression. I think I have mixed feelings over this. It doesn't say tribal utilities. It just speaks to tribal priority projects. So the state or county may be able to say to us, we get it on a tribal priority project, or it won't be done with any of our money or forces. I'm concerned with the interpretation from crossover regulations when FHWA delegates their funding regulation to the state. This bill is the concept. The regulations will define the actual policy under which it is defined practically. Tribes should have comment periods relative to changes to the policy, but they may not be able to change this direction. So we obviously appreciate the information on this, Brianna, and I think, Nichlas, are you going to share everyone's contact information? It sounded like you had a comment in there to do that.
Yeah, I'm happy to do that. Should there be somebody in the group today who does not want that to happen, you can send me an email or send me a direct message on here before we end today's meeting, and I'll make sure that you're excluded from that list.
Great. So Brianna, why don't you reach out to Nichlas directly, and that way we can come together as a group and discuss, you know, our next session. And I think rights of way will be something that will be a reoccurring topic on this Talk Shop series. So we want to make sure we address, you know, your questions and concerns. So. And then we've got one comment from Danny. I also had a question regarding allotted trust property. Okay. We have a case where a major intersection needs pedestrian crossings because there's a lot of traffic, but one corner is owned by a single owner in allotted trust who died 13 years ago and is in interstate probate. Is there any way to get that right of way?
Yeah, the Bureau of Indian Affairs can approve grants of right-of-way for intestate estates. So allottees who have passed in their estates in probate, BIA can grant those for them.
Thank you, Sarah.
Yep.
And I think we'll take one last comment from Brianna. I work for the tribe looking to document tribal utilities and tribal road rights-of-ways. The BIA did not record records that were turned over to them. You know, that is one thing that has been a large effort on our end, being San Pasqual. You know, when I started working for the tribal government, you know, I had experience in the private sector and kind of the process involved there for rights of ways and documenting these things. And so it was definitely a wake-up call. And so it is incumbent, it is in the best interest of the tribe that at every opportunity you have to document and even correct documents. We've done that. We've amended rights of way, legal descriptions, and things of that nature, and it just provides for a better recording system. It really is up to us. So if you have the resources to do that, you know, we've hired interns, you know, from with GIS backgrounds or even serving local schools. So there are opportunities to do that, because I know cost is definitely a concern. So so I would take advantage of employing interns and then just get connected with us, and if there's anything we can help with, we'll certainly do that. All right, Nick, what do you say?
All right. Well, thank you very much to the members of the board who lent their expertise to this conversation today. I think that this has been a really powerful conversation. You know, I've had some people DM me already asking for a longer session next time around. So we'll have to see how this goes. We'll talk with the board and we'll figure out some solutions. But we do appreciate everybody tuning in to our pilot series of Talk Shop and the rights of way discussion that we had today. In the chat, I did put the link to the next full webinar, which is next Wednesday, a week from today, 15 September at noon Central on FIDA Trust. We're going to have a talk shop on this very topic, or on the FIDA Trust topic, I should say, on October 5th at noon Central. You're going to get emails about those things. Just want to let you know. So please do let me know if you do not want your information shared with other members of this group. And until next time, have a good week.
Thanks, everyone.